Okay, so hopefully everyone can hear me and can see the screen. Uh, Welcome to the last of the Ask Me Anything sessions in relation to the Bahamas FTX liquidation process. So my name is Jason Gunter. I'm a director in PwC's restructuring team in London. I'm joined today by Luke Groth, a partner in our team in Hong Kong. As I mentioned, this is the last one of these sessions, but the objective of the session today is to work through some of the most regularly asked questions that we're being asked by creditors of FTX leading up to the election deadline. I'll set a bit of context just on the next page. So many of you may have a number of questions in relation to the process, which might range from what is the difference between the Bahamas and the US process? How do I submit a claim? Am I eligible for the Bahamas process? When will I get paid? Do I need to vote? How will I get paid? Will there be withholding tax? Do I need to redo KYC if I've already done it? The aim of this session is to try and answer some of those practical questions, recognizing that the work is ongoing in relation to the liquidation and winding up procedure, and some of the things that we will talk through are subject to change. But we will do our best to answer your questions as we go through. As we've run a few of these questions now, I think we're starting to get a relatively good feel for the sorts of things people are interested in understanding. So I'll probably spend around 15 to 20 minutes just walking through 6 or 7 slides, which I think are responsive to a lot of the questions that we've been asked already, and a lot of the questions that people are posing on social media. Then after that, we'll open up for general Q&A. And at that point, if you do still have a question that we've not answered yet, feel free to use the Q&A function in the chat, in the sort of toolbar in Zoom, and we'll work through those thematically first, and then work through some of the more specific queries we receive. So that's the objective. We'll probably run for about an hour on the main call. And then to the extent people need to drop off after that, feel free to drop off. If there are a few of you who still haven't had questions answered, after that, we might be able to stretch a little bit longer. So if we turn to the first substantive slide, the Bahamas process. So where are we from a process perspective right now? So customers of FTX.com or FTX International were able to start submitting claims in the Bahamas process from around March of 2024. And at the time, many of you will be aware that there were effectively parallel processes running between both the Bahamas and the US in relation to processing, dealing with, adjudicating, and ultimately paying out FTX.com claims. As we move forward from the 16th of August onwards, customers who have a claim against FTX.com will need to choose whether or not they continue to have their claim processed in the Bahamas or the US. Ultimately, the claims relate to the same underlying amounts, and the intention is not for people to be able to duplicate their claims or claim in more than one jurisdiction. So from the 16th of August, if you wish to proceed in the Bahamas, you'll need to elect to do so. That election process has been open since the 10th of July and will run until 4 p.m. prevailing Eastern time on the 16th. From the 16th, once we have passed the bar date and we definitively know which customers are either in the Bahamas process or in the US process, in the Bahamas process, we will proceed through KYC and AML procedures, which customers will be required to pass to be eligible for distribution. And we expect to start those procedures in September, and they'll carry through to around the end of the year. And then distribution payments are anticipated to begin in Q1 2025. So why are there multiple processes, and what is the election, and why are we going through this election process? Well, in the ordinary course, in a liquidation or a bankruptcy proceeding, liquidations tend to get carried out on a legal entity basis. And what will happen when a business enters into some sort of form of insolvency or bankruptcy proceedings is you will look at the assets of a legal entity, you will monetize those assets, and you will pay those assets to the creditors of that particular legal entity. The complexity with the FTX exchange is that it operated across over 200 legal entities in dozens of different jurisdictions. And what we refer to colloquially as the FTX.com or the international or the non-US platform was effectively run on a basis which didn't attribute the running of that to a particular legal entity. At certain points in time, FTX Trading, which is an entity in the Chapter 11 process, was running parts of the FTX.com exchange. At other points in time, FTX Digital Markets, which was an entity incorporated in the Bahamas, which is being wound up under the Bahamas proceeding, was running the FTX.com platform. Because of the very well publicized state of the books and records of the company, notwithstanding a significant amount of forensic analysis by multiple parties, it's not been possible to delineate between the assets and liabilities of FTX Trading and FTX Digital Markets. Essentially, all of the assets and liabilities were hopelessly commingled. Therefore, because it's not possible to unravel the affairs, rather than enter into some form of jurisdictional litigation between the Bahamas and the US, it was decided to effectively join up the two estates and pool the asset recoveries across those estates, allow FTX.com creditors to claim in either estate, depending upon their personal preference, such that both estates will pool recoveries to pay creditors in those estates on the same basis. So it's anticipated that those customers will receive the same distribution amount at broadly the same points in time through the same distribution mechanisms, and will also have to pass many of the same or meet many of the same requirements in order to be eligible for payment. So in summary, any FTX.com customer can proceed with their claim in either the US process or the Bahamas process. The processes have been designed to ensure that there's not particularly any arbitrage between the two. They're designed to be broadly the same and fair and equitable to customers in both. And critically, there can't be any double dipping by customers. So that's why we're going through the election process now, such that if customers want to continue having their claims processed in the Bahamas, they make the election before the deadline, and they can do so. So to participate in the Bahamas process, you need to do a couple of things. You need to do two things specifically. Number one is you need to submit a proof of debt form. And number two is you need to elect to participate in the Bahamas process. Both the proof of debt form and the election form are both available on the digitalmarketsclaim.pwc.com portal. If you have an FTX.com account, and if we have a record of you having a claim, you can log on to that. You can create an account on that portal. You can connect your FTX.com account When you connect your FTX.com account, you'll be able to see the balance record that we have against your particular account, and you can lodge a proof of debt form. If you agree with the balance that we have listed against your account, you can simply lodge your proof of debt form on an acceptance basis. You will proceed therefore then to the election form, and you'll need to formally elect into the process. If you disagree with the balance against your claim in our portal, you can dispute the balance. You can lodge an alternate proof of debt form in the balance you think you're owed, and you will then again proceed into the election process, and you'll need to make an election to continue in the Bahamas process. We'll then go through a few different stages in the process, so namely adjudication and KYC. In order for you to be, if in respect of adjudication, if you have agreed with or accepted the balance that we show for you on the portal, adjudication is just a formality. Adjudication applies more so to customers who have disputed their balance. For those customers who've disputed their balance, we'll ask you for supporting information or any documentation you can provide to us to help you understand what you think your balance should be. And you'll go through a formal adjudication process where that information will be considered. And if ultimately we review the information and consider that your claim has been misstated, for some reason, we will adjudicate upwards the claim value, and your claim will then be admitted on a reconciled basis in that manner. So that's the Bahamas process. Just in relation to key differences between both the Bahamas process and the US process. Well, actually, let me start with key similarities, which are set out on the left-hand side of the page. So in terms of similarities, the claim value assessment process, calculation and valuation methodologies are the same and performed at common dates. So the claim balance that you can see on the FTX digital claim portal is a function of the quantities of any particular tokens that were held in an individual's account, or the quantities of tokens they would have been entitled to under the closure of any open contracts, converted at the token conversion rates into a USD fiat equivalent amount at the 11th of November 2022 at 10 a.m. Eastern Standard Time. And both of those calculation methodologies have been performed on a common basis between both the US and the Bahamas process, and the conversion rates have both been approved by the respective courts in both of those processes. So by the Delaware Bankruptcy Court in the US and by the Supreme Court of the Bahamas in the Bahamas. The procedural requirements to be eligible for payment are the same. So all customers will need to pass KYC, AML, and provide tax reporting information, or more specifically, customers will need to submit an IRS W-8 or W-9 form or equivalent. And the KYC and AML requirements will be common between both the Bahamas and the US process. In terms of distributions, as I mentioned at the beginning, the quantums and timing of distribution will be the same between both processes, as will the distribution payment mechanisms. So traditionally, in a bankruptcy or insolvency, you might expect to receive a distribution payment either via a physical check or a bank transfer. In this particular case, we're still working through the details, but the intention is to appoint a payment agent through whom distribution payments will be transacted. That payment agent is likely to be either another crypto exchange or a payment processing firm. where customers will be able to take their distribution entitlements either in a USD stablecoin format or in fiat. Again, that will be the same between both the Bahamas process and the US process. We anticipate using the same payment agents. So if we could just go back to the previous slides, just a couple of points in respect of key differences between the two processes. So the key difference between the process is in relation to disputing claim balances. In the Bahamas process, you're still able to dispute the scheduled claim balance up until the bar date of the 16th of August at 4 p.m. prevailing Eastern time. That means if you log into the portal and you see a claim balance that you disagree with, you can still dispute that claim balance and go through an adjudication process. In the US process, their bar date passed on the 29th of September 2023. So to the extent that you did not dispute your claim balance before that point in time, you are now no longer able to do so. So you will still be eligible for a claim in the US, but that claim will be fixed at your scheduled balance. The other difference between the Bahamas and the US process, which won't apply to many of you, is just in respect of de minimis claim values. So under Bahamian law, all creditors are entitled to a distribution payment, no matter the size of the creditor. In the US, they are striking a de minimis level at $10, where they won't pay claims out below that amount. In the Bahamas process, claims below that amount will be paid out. If we just move on to the next slide now, which walks through the approach to distributions. So there are a number of different classes of creditors across the wider bankruptcy process, but just focusing on FTX International or FTX.com customers, their claims will fall into one of two different categories. They'll fall into either the convenience class, where if you have a reconciled claim value or a principal value of your claim of $50,000 or less, you will receive a single full and final distribution payment equivalent to approximately 119 cents on the dollar, paid during the course of Q1 2025. The 119 cents on the dollar reflects the principal balance of your claim calculated on the 11th of November 2022 reference date, plus accrued simple interest calculated at 9% per annum accrued on your claim value until the date of your full and final payment. Any customers who have a principal claim balance of US $50,000 or more will not automatically be a part of the convenience class. You will form a part of the main class of customer creditors. You will also be entitled to an amount representing post-petition interest calculated at 9% per annum simple interest. You also may receive a share in proceeds from what we call the Supplemental Remission Fund, which I'll talk through in a little while. But your claim balances will be paid out over a longer period of time. Broadly speaking, we expect your first distribution payment to be paid shortly after the convenience class, so within a month or two. However, that payment should represent a sizable or a material payment amount on a cents in the dollar basis. But your overall recoveries will be dependent upon and driven by the further asset recovery processes in the estate. So there are still assets that need to be liquidated across the estate, which include both cryptocurrency and physical property and real estate. As those recoveries are completed, you'll receive staged distribution payments over time, and you'll continue to accrue your post-petition interest on outstanding principal amounts that haven't been repaid yet. You may also receive a share of proceeds from what we call the Supplemental Remission Fund. The Supplemental Remission Fund basically represents the claims that certain government and regulatory agencies have made against the debtors in the US process. So this includes agencies like the Chicago Futures Trading Board, as well as certain securities bodies, both on a local and federal basis. Some of those agencies have lodged claims against the FTX estate for non-performance of regulatory requirements and may be eligible to receive a distribution from the estate for those fines. There's a commercial discussion underway between the US bankruptcy debtors and some of those claimants in respect of allocating the distribution payments that they would be entitled to customers, or effectively to the victims of the failure of the FTX exchange to comply with those regulatory obligations. So those supplemental remission fund distributions are factored into the upper end of the distribution band that you can see on the page there. The lower end is dictated more by the post-petition interest. However, both of those numbers ultimately are subject to change because they're dependent both on the timing and distribution amounts as well as the asset recoveries. So if we just flick onto the next page, that broadly addresses most of the questions that we've picked up thus far through these Q&A sessions. I might turn over to Luke at this stage to pick up on any Q&A that's been dropped into the chat or cover anything that he feels I've missed.
Thanks, Jason. So there's a few questions in the Q&A, so if anyone wants to start putting some more in, please do so. You can do so at the bottom of the Zoom under the Q&A function. I think I might just take the first question and just cover some items around the process. So I think the first question on the process, which is simple to answer, is if I've already submitted my US claim and I choose the US process, is there anything else I need to do at the moment? And then there's a similar question which is related, which is what happens if I don't say where I want to take part in a procedural process? So the way it works in the US and the Bahamas is slightly different. So in the US, everyone who had an FTX.com platform account was put on what they called the schedule. And that schedule was released a long time ago before the US bar date. And so the default position of anyone with an FTX.com account is that you are on the US schedule. If you do nothing in the Bahamas process, i.e. you don't submit a proof of debt in the Bahamas process, you will continue to remain on the US schedule, and that claim would exist in the US process. Now, you won't necessarily get paid if you do nothing. You will still have to liaise with the US debtors to fill in your KYC and your tax forms in their process if you want to receive a distribution. But from lodging a claim, there's nothing more you need to do in the US process. So if you wish to be in the US process and you have done nothing in the Bahamas process, you don't need to do anything here. If you had previously sort of submitted in both, or you submitted a proof of debt in the Bahamas a long time ago and you wish to stay in the US, what we would encourage you to do is to go on to the digital markets claim portal that we put the link up earlier, and then you'll be able to actually elect and confirm to us that you wish to withdraw your proof of debt in the Bahamas and go to the US process. But if you've never interacted with us or submitted a proof of debt and you don't do anything, you will remain in the US process, and after the 16th, that is where your claim will be handled. Jason, I might throw the next one to you, so around tax. So there's a few questions. So one is for a non-US FTX.com customer, is US or Bahamas withholding tax applicable? Maybe start with that one.
Yeah, thanks, Luke. So the withholding tax question is one that's being asked a lot, and the honest answer to this is there's a lot of structuring work that is still very live and underway at the moment, which means that the tax position in relation to distributions may continue to change. I guess what I can tell you to try and be as constructive as possible is a lot of the structuring work that's underway at the moment is being done with the intention that there should not be withholding tax applied in either the US process or the Bahamas process to distribution payments made to customers. That's not locked in, it could still change, but the structuring work is being done on that basis. To the extent that we do end up in a position where withholding tax does need to apply, that outcome will be mirrored between both the Bahamas process and the US process. So in simple terms, if withholding tax applies, it will apply equally to both. If it doesn't apply, it will equally disapply to both. Just as a follow-on, in respect of income and capital gains tax more broadly on distribution payment amounts, that's ultimately going to be a matter for individual customers. As I mentioned, we're working with creditors across 20 or more jurisdictions. The tax treatment of distributions may vary on a jurisdiction by jurisdiction basis, and it will be for the individual customers to ensure that they comply with their local tax requirements in respect of reporting and payment. Just a final point in relation to withholding, we will be requiring that customers submit IRS W8 and W9 forms as part of this process. One question that some customers have asked a lot is, if ultimately withholding tax is not required, why are we still collecting those forms? Well, there's also a practical reason for that as well, which is some of the proceeds that will become available to the FTX Bahamas creditors will be made from US bank accounts and US banks. Those US banks have certain compliance requirements and thresholds that we need to satisfy in order to ensure that they provide those funds onto us, which includes the collecting of these forms.
Okay, I'm just looking down. So there's a few questions on FTX EU that I might just quickly cover. So one is why the FTX EU balance is not displayed. They're displayed in the US process. And there's another one regards to, how should FTX EU customers proceed generally? Should they go into the US or Bahamas process despite having their own EU process? So FTX EU is just a very special category of customers. EU customers sort of use the underlying platform infrastructure, but for the purpose of the various insolvency proceedings, FTX EU customers are not either in the US process directly or the Bahamas process directly. So from the Bahamas perspective, we're not dealing with FTX EU customers as a general rule, and there is a separate FTX EU bankruptcy or insolvency process where they will be communicating to you how to repay any funds through that process. There is a slight exception on that, in that anyone in FTX EU who was doing a crypto withdrawal that did not settle on the blockchain, and by crypto, pending crypto withdrawal, what we're talking about is you asked, for example, for a Bitcoin to be taken out of your account and paid to you, but it never actually, so it came off your account, but the transaction never settled on the blockchain and you never got the digital asset in your wallet. So those pending crypto withdrawals were actually handled through FTX Trading and FTX Digital Markets and the main platform. So any pending crypto withdrawals for FTX EU customers will be paid back by the trading process or the digital markets process, our process. So For FTX EU customers, you effectively need to do two things sort of to get theoretically all your account balance back. You need to go through the FTX trading or our FTX digital markets Bahamas process to claim your pending crypto withdrawal. And then you need to liaise with the FTX EU insolvency process around how you get the remaining account balance back that you've got. In terms of just making the claim on our process, all the FTX EU pending crypto withdrawals are loaded up to our portal. So if you're an FTX EU customer and you're not sure if you've got a pending crypto withdrawal, if you log on to our digital markets claim portal and you put your email address in, if you do have that pending crypto withdrawal claim, it will automatically come up when you link your ftx.com account and you'll be able to see what that is. Jason, do you want to maybe cover there's a question around will we be can you explain maybe the payment providers, how that works, and will stablecoin be available for creditors to choose in terms of receiving payments?
Yeah, no problem. So again, this is still live. There are continuing discussions underway in relation to payment agents, both commercial discussions and contracting discussions. So again, this is subject to change, but the most likely payment agent option looks like another cryptocurrency exchange for retail customers, where it's anticipated that the distribution payments made across to that exchange for customers' benefit will be capable of either being traded or taken as stablecoin or taken off the exchange as fiat. Ultimately, customers will need to either have an account with that payment agent or set up an account with that payment agent. And your distribution payments will be made across to that payment agent at relevant distribution times. We're looking at payment agents that have broad geographical coverage, but there will be some jurisdictions in some edge cases where a particular payment agent cannot make its services available. And in those edge cases, we will need to look at either bank transfers or checks to make payments.
Thanks, Jason. I'm just going to cover a few questions just on the processes and where we're up to. So I think there's a question around, I'm still in adjudication. Is this correct? There's another question around, I haven't done KYC in the US process. You know, I understand it can be done in the Bahamas. Will that happen? Or when will that happen? And then there's one around the actual Bahamas KYC documentation asking, you know, the question is around the source of funds corroboration, and are we going to be asking for bank statements, or is it possible to submit other crypto trading statements as part of your source of funds? So let me just, and sorry, one more question which I'll cover is, I have not been asked for my W8 or W9 yet in the Bahamas process. When will that happen? So the Bahamas process is not going to start for the KYC adjudication and W8, W9 collection until after the election is closed, which is this Friday on the 16th of August. And the reason for that is because if people do not end up in our process, we do not want to be collecting documents or doing KYC or adjudicating claims that ultimately we are not going to pay. So with regards to adjudication, no one in the Bahamas process has been formally adjudicated. Although if you've accepted your balance when you submitted your proof of debt in the Bahamas process, that adjudication will be a mere formality, and at some point you will get a letter saying that effectively we've agreed with your claim balance, and then you'll pass that step very easily. If you've disputed your claim balance in the Bahamas process, those things will be looked at over August and sort of September timeline. There may be some questions that are asked of you in regards to supporting your position on adjudication. And then once the JOLs have looked at the claim and come up with what they believe the claim value is, they will issue you a formal letter saying what your adjudicated claim balance is. In the Bahamas process, if you then want to further dispute that adjudicated claim balance, I think we'll provide the instructions, but it will require you to then do something in Bahamian court to dispute the claim balance that the JOLs have assigned. And that dispute process, we will provide information when we provide those adjudicated values. So that's the adjudication process. KYC, again, has not started yet in our process, but we do know a number of people have already submitted KYC information to the debtors. So generally, and especially for individuals, those who have gone through some sub and submitted their KYC documents, when you opt to come into the Bahamas process, there's a release that we've asked people to sign to say that the debtors can send any KYC information you've already provided them to us for the purpose of us completing your KYC. So where possible, we will not ask you to resubmit KYC documents in terms of your ID or proof of address. We'll get access to what's already been done in sub, and then we will look at those records. And while we're not just copying exactly what debtors have done, generally, if you're KYC verified in the debtors process, it should be fairly simple to get KYC verified in our process. In most cases, there may be some slight variations where we want to ask some more questions, but generally it should be fairly simple. With regards to KYC source of funds information, so as part of our AML checks, certain individuals, but not everyone, may be asked to substantiate how they originally seeded the amounts in their FTX account, and that would generally be around the original deposits in and where that money came from. I don't want to comment specifically because it's going to be different case by case depending on what people tell us about where their source of funds came from and how that money was made. But I do believe that, being able to show other crypto trading profits would be one of the pieces of evidence that we would consider when assessing source of funds. But that will be on a case by case basis in accordance with our AML procedures. And then just to loop back on the final bit around the tax forms, again, we haven't requested any tax forms yet. That will happen probably around, sort of October time this year, where on the portal, we will direct customers to submit a W8 or W9 as required. And there'll be a technology solution for you to be able to do that online through our portal or a similar third-party portal that will allow you to submit it. And that will happen well before that we are planning to do distributions in Q1 2025. So that's, again, in our process, post the 16th, we will use our claims portal to sort of inform customers of the next steps, which is adjudication, KYC, tax forms, and some other information around your election of which payment agent or distribution agent you may wish to use to receive your funds.
Luke, maybe I'll just jump in with
sure.
another general question that I've spotted. There are two related questions. One person has said that they had Bitcoin on the exchange and they'd much rather have their Bitcoin returned rather than paid in a US dollar equivalent. And another person has asked to confirm that the interest will accrue equally on a person's claim, whether or not the underlying claim they had was in relation to Bitcoin or cash. So the answer to those questions and the reason for the answer to those two questions both comes from the same place, which is there were a large number of tokens that were missing from the platform. And Bitcoin is the clearest example, because I think across all of the estates, the platform information indicated that the exchange was holding 100,000 or so Bitcoin tokens on behalf of customers. However, ultimately, only 100 Bitcoin tokens were recovered. So many of the more valuable cryptocurrency tokens that people had on the exchange just weren't there to be recovered. Those that were recovered were commingled into general wallets and trading accounts, and they aren't capable of being traced back to individual holders. Also, so that's one reason. The other reason is the reason why it's been possible to generate recoveries across the estates, where the anticipation is that convenience class will receive something in the order of 119 cents on the dollar of their 11th of November claim balances, and other customers will receive higher recoveries over a longer period of time, is because some of those recoveries have been driven by other pockets of value. So either other categories of tokens that have inflated in value, or venture capital investments that were made by the exchange or Alameda that have inflated in value. And it's because of recoveries across those pockets that the distributions are available. And therefore, the decision has been made to apply those recoveries equally across all claimants based on the reference claim values.
I might just pick up a question related to, there's a few quick process questions I'll do. So someone's asking about spam hacker emails and what are the legitimate communication channels. So very simply on that, just for everyone on this call, generally the JOLs and the debtors will not be asking you via any emails to submit information to us, especially around doing anything like linking wallets or providing information via email for payments. All of our information around how we're going to ultimately distribute you will get submitted through our secure portal. Although we may contact you for emails if you've submitted queries through that. If you want to see which email addresses are legitimate, both in the Bahamas process and the US process, you can go on to our official website, which is pwc.com, and there's an FTX Digital Markets in official liquidation page, and on that there's a link in there that will show you all the different legitimate email addresses that we use to communicate along with the debtors. And then I guess similar to that, there's a small process question around confidentiality of information, and will things be released publicly or indirectly if I choose the Bahamas process? So as a general rule, the answer is no. We do not have sort of, the Bahamas adjudication process will not sort of go through the courts as a general rule. So it's a bit different to the US process for those who have been involved in it, where a lot of the information's appearing on dockets and they're putting customer numbers on and redacting things. We don't do that. So with regards to adjudication, you will be dealt with directly via the JOL team. The only time that might become public is if you then ultimately wanted to file something in the Bahamian court in dispute of your claim. Depending on the process you need to go through for that, some of those documents may become open court documents and people may be able to see. And then just in terms of other sort of client confidentiality and data questions, I think Jason already touched on it, but we are required to collect those W8 and W9 tax forms as part of our obligations around making distributions. And there is a possibility that we may be asked to provide those forms to US regulatory agencies or the US debtors as part of us just supporting the fact that we are not going to be paying withholding on any of the distributions to customers. So those forms for individuals are fairly simple though. And when you see them, you'll see that it's mainly sort of name, address, and country of residency, and kind of, you know, what your tax status is. But yeah, so there is some information, but nothing will be disclosed publicly, except maybe if you go through a Bahamian court process. Jason, there's a few questions on, is there possibility of you know, one process paying back creditors or not? You know, what would happen if the plan was voted down? What would happen to the Bahamas? And how does the Bahamas, like, can I vote for the plan in the Bahamas process? So do you just want to maybe cover how that is kind of working?
Yeah. So a material portion of recoveries that are anticipated to be paid will come from the US side of the process. So as I mentioned in the beginning, we've agreed to pool asset recoveries across both the states to the benefit of common creditors. The ability to pool is dependent upon the implementation of the reorganization plan. And at the same time that we have this election process underway, customers and creditors also have until the same date to vote on the implementation of the reorganization plan via the Kroll website. If for whatever reason the plan were not approved, then the current pooling approach and process would not be capable of continuing. In that scenario, I think the advisors would go back to the drawing board. The plan would be amended for whatever features needed to be amended in order to gain the requisite approval, and it would go out to vote again. So that's I guess a relatively long-winded way of saying that the Bahamas process still has some contingency, or some dependency rather, upon the US process proceeding. In relation to voting on the plan, if you elect to continue in the Bahamas process, you're not being specifically asked to vote on the US reorganization plan. However, it may be that the US debtors look at the elections in the Bahamas and take that as implicit approval of the plan. The other question that comes up in relation to voting in the US process or electing in the Bahamas process is in relation to third-party releases. So some of you may have seen on your US ballot forms third-party releases that you're being asked to sign along with the approval of the plan. And the question is, how do those third-party releases operate in the Bahamas? There are no specific third-party releases, and the operation of those third-party releases in the US is generally, if you vote to approve the plan, you're then asked to release from liability relevant parties that have input into the plan. In the Bahamas, we don't have that. We don't have third-party releases of that nature. However, if you do elect to proceed in the Bahamas, you will be asked to release your claim against the US in its entirety, and that's for the reason that we set out at the beginning. From the 16th of August onwards, claimants will only be able to proceed in one process or the other, and depending on which process they proceed in, they'll need to release claims in the other. So if, for example, you want to go down the alternate route and proceed in the US, and you had previously submitted a claim in the Bahamas, you actually need to positively elect in the Bahamas to complete that claim. So if you've not positively elected in the Bahamas, your proof will be deemed incomplete and withdrawn after the 16th of August.
Okay, I might just pick up a few questions around dilution. So some of you are asking, there's a comment in the election process overview document that we put out, which says dilutions, you know, in the Bahamas process could occur if the JOLs accept incremental claims in excess of 75 million of the scheduled balances. However, based on current information and claims to date, the JOLs do not anticipate this will occur. And there's a question which means, is there a potential, does this mean there's a potential that the Bahamas process creditors will be diluted more than creditors in the US, or is there a potential dilution for both? And then there is another question asking, because of the Bahamas paying out $10 and less claims, will that potentially result in less payouts to Bahamas participants? And then there's a third one, which is because we have not completed the claims process and people can still submit proof of debt, is dilution possible? So dilution is something which is in the global settlement agreement, and it's really a technical clause that's in there to prevent the JOLs sort of arbitrarily just coming up with assessing claims and then providing large payouts to creditors in the Bahamas process, which is higher than what the US process would have paid out. So this is more of a technical legal item that's in there. And as we said in that election document, we do not anticipate that we will go anywhere near the 75 million cap. The way it works is the schedule of claims has been agreed between the Bahamas process and the US process from a methodology and calculation perspective. And both processes, because we've pulled assets together, the amount of recoveries that we anticipate to pay out, which is the 119 cents for convenience class or higher for non-convenience class that Jason referred to earlier, that is calculated on the schedules that we already have. And people who are submitting claims in the Bahamas process, we are using those schedules to work out what we can and cannot pay back in terms of distributions. When it comes to sort of the adjudication of those claims, where there's a legitimate reason for us to pay more than what's on the schedule, and I talked about processing withdrawals before in the EU context, but there are some situations where a customer in the FTX.com platform has not received a payment out of their account, and we need to sort of amend the balance to reflect the fact that a payment was not settled right at the end date of when the platform ceased operation. So all of those types of amendments will not go into that 75 million cap. We will agree them with the debtors, and that will all be shared equally across both estates. So I think just to sort of close on that, it is a technical possibility that could occur. But at the moment, because we are assessing claims on the same basis as the US debtors, we don't anticipate that we will go anywhere near that 75 million cap. And just to close out then on the question, is there any possibility that one process could get paid over the other, which I saw earlier. The GSA is the mechanism that provides the pooling between the two estates, and in that mechanism, it provides for both groups of creditors, whether you're in the Bahamas or US process, to sort of be treated equally. So I think it's a very, very, very slim possibility that would happen. The only circumstance would be if there was some dispute between the Bahamas process and the US process that delayed payments. Otherwise, per the GSA, there's a contractual agreement that the both groups of customers will be paid from sort of the same pool of assets, and therefore, with the exception of I guess minor process differences, the plan is that both people will be paid a similar amount at a similar time. Jason, any other ones you want to pick up? Or maybe let me just pick up one on coin and liquid. So coin or QUIONE was the Singapore sort of FTX entity, and liquid. I think there's liquid Japan, and then there might be a liquid US. So both those entities are not in our process. So we only deal with FTX digital markets customers who are part of sort of what we call the international platform. So coin clients, you'll have to refer to the US process, which is going through that separate process. Liquid Japan, I believe that those account holders have already been able to withdraw funds, The main difference with Liquid Japan is that some of the assets were held in separate bank accounts and they were segregated. So those customers were able to be returned their assets in kind through a withdrawal rather than through this liquidation process. And so they should have, if you're a Liquid Japan customer, you should have been emailed by the Liquid Japan process, which is being run by the debtors with instructions. But neither of those customers are relevant to FTX Digital Markets. If you're unsure, you can always go onto our claims portal and try and submit a proof of debt and link your account. And if you put your ftx.com email address in and it won't link your account, or it says you can't find your account, it's likely because if you're probably not a customer in our process from the perspective of you're not an FTX Digital Markets customer.
I might just jump in,
Jason.
Luke, and answer a couple more KYC questions that have come through. So one is, there are some creditors from Ukraine, Belarus, Russia, etc. Will the Bahamas pay those customers? So customers will need to pass KYC and AML processes to be eligible for payments, and those processes will include sanctions screening. Sanctions will apply to individuals rather than countries. So if individuals do not pass sanction screening, they will not be paid. But just because of a sort of broader jurisdiction that a customer is based in does not mean that they will automatically fail those KYC tests. There may still be certain practical challenges that apply in respect of distribution payments, depending on availability of the payment agent operating those procedures, or the ability to actually transfer funds into bank accounts. But if those apply, they'll just need to be worked through in those edge cases.
Okay, I might just pick a few more up around. So there's one question around, will successful class action lawsuits in the USA have an impact on payouts in the Bahamas? I don't want to go into this too much because it really will be something within the US debtors process. But as we mentioned, per the GSA, the assets of both estates are pooled. So yeah, there is a potential if there was some sort of lawsuit in the US process which required to be paid out of those pools, then yes, that may impact both the Bahamas and the US process payouts, but that would equally impact both sets of customers because the same pool would potentially have funds taken out from it. Yeah, but whether or not it would depend on the type of claim and where that money was going to be paid out from. So it may or may not impact the payments to creditors depending on the type of action. But that would have to be looked at specifically in the context of the US legal process. There's one that also says what to do in the Bahamas process if I do not agree with the amount to be paid out due to the terms of service. As we sort of mentioned before, the way that we're adjudicating claims in the Bahamas process is fairly aligned to the US process. So if you don't agree with the fact that the valuation methodologies that we're using, or you don't agree with some of the other ways that payments happening, it's unlikely the JOLs will adjudicate in your favor, purely because just the way that the process has been run, we're using the same set of rates for everyone, and we're not having different calculation methodologies based on individuals' preferences of how they want their claim to be calculated. And those valuation rates have been approved by the courts and have had experts look at them to agree what they should be. So if you disagree, I guess, with the methodology rather than the your individual circumstances, probably what would happen is the JOLs would not adjudicate in your favor and would say, no, we still believe it's still the scheduled amount, and we believe it's what we've told you already on the schedule. And then you would have to file with the Bahamas court to dispute what the JOLs have adjudicated for you, and that would be a Bahamian legal process. So that would be in the Bahamas. In the US, if you don't agree with the scheduled balance, I think it may be too late because the bar date has passed and they won't be accepting any further disputes. But similarly, what happened in the US process, if you didn't agree, was you would put it in, and then they would have to put that dispute on the docket and go to court to get adjudication. But I believe that is probably closed now in the US process from a disputing it. But there may still be legal actions that you can do there. We won't comment on that. So I'm just looking at some of the other questions. We said claims for Bahamas started in April 24. However, my claim was created before April. Is this still compatible with the Bahamas process?
Yeah, I think
the Bahamas. Sorry, Jace, you go.
Yeah, I was just going to say, Luke, I think that was me. I think I misspoke in the original overview and said April 24, although I think technically customers have been able to submit since the 28th of April. Sorry, the 28th of February.
In February, yeah. So I think the important thing here is if you have a Bahamas proof of debt on our portal and you've submitted the election to say that you wish to remain in the Bahamas process on our portal, you should have received an email confirming that when you made the election in the Bahamas process. That means your claim will remain or will be in the Bahamas process post the election deadline. There's a question on will the distribution agents be disclosed for both Bahamas and US? They will, but likely not before the election process is completed. That is still because we're going through due diligence and contractual discussions with those payment agents to work out which one provides the most value for creditors. But as we sort of alluded to, they will be fairly aligned, if not fully aligned, across both processes. So it should not really make an impact from choosing the Bahamas over the US. There's a question: if I elect the Bahamas process now, but later find out I'm entitled to more as part of a new class action in the US, will I be able to join that new class action? I would suggest you get legal advice on this. As we mentioned, from a claims perspective, there is a release that you sign to release the US when you come to the Bahamas process to get paid. It is possible that may or may not apply depending on what the class action lawsuit is, what it's about, and whether that would be impacting your FTX.com account balance, or it could be a completely separate class action that is outside of kind of the balance calculations. So I think you would need to go and get legal advice on that to determine if that would be would mean that you might lose that right if you come to the Bahamas for your claim. So just looking down, are only non-customer creditors of FTX Digital permitted to file a proof of debt, or can a non-customer creditor of other FTX entities file? So for us, for non-customer creditors, it's only non-customer creditors of FTX Digital Markets. So you would need to have a contract with FTX Digital Markets as a supplier or an employee would be the two main classes. If you were a supplier of FTX Trading Limited or one of the US debtor entities, you would need to have your claim go through that process because we are not. So the GSA only allows for this pooling arrangement and dual process for customers of the .com platform because of the way that those customers, were one big pool. But from a non-customer creditor perspective, so employees or trade creditors, you will need to file in the appropriate process. Just a quick, just to highlight, the bar date in the Bahamas for non-customer creditors is also the 16th of August, which is this Friday. So any employee of FTX Digital or any non-custom creditor of FTX Digital, please do also submit your claims through our claims portal process. Choose non-customer creditor at the start before the 16th.
There are a couple of other questions here which I think we've answered, but people might have missed them. But just briefly, there's another question regarding the first distribution date for non-convenience class creditors. So we said previously we anticipate the first distributions will be in Q1 25. The convenience class distributions will be paid first, and I would broadly anticipate that the first distribution for non-convenience class would be within a month or two of that payment. There's another question just clarifying W8 forms. So if you need to submit a W8 form, when? Again, we're working towards an objective of making a payment in Q1 2025. So therefore, we need to work through all KYC and tax form collections before that. We'll likely be asking you for those W8 or W9 tax forms as applicable before the end of this year.
Yeah, so I'm just looking at the time. So we're a little bit past the hour. So I think we will continue just to go through a few final questions, maybe for the next 10 to 15 minutes. But I guess while we do, for those who have had their questions answered, feel free to drop off and leave the session. And thank you for attending. I think I just did note there's sort of a few questions around, how do I get support? How will specific queries be answered? So please do email the GBL FDM customers@pwc.com email. I know that some people are saying that it is slow to receive queries via that. I think that's probably going to be only for very specific queries. Generally, we're turning things around, anything related to submitting a proof of debt within 1 to 2 days. But sometimes it does take a little bit longer for us. If you've got a query around linking or locating your account, it does take time for us to investigate in the back end. So please bear with us. But just so anyone who wants to submit a claim in our process, if you are having problems with the portal, if you're having problems linking your account, this week the support team will be sending you a manual proof of debt. So if you have a query that's related to actually submitting your proof of debt and the election, please do reach out via that support email address, and we will endeavour to get you that manual proof of debt form ASAP this week, so you can send it back to us via email. And then for more complicated queries, we will continue to deal with them after the election deadline and get back to people. Okay, so thanks for all those who have joined today, and we'll just continue to pick up questions maybe for the next 15 to 20. So there's one I might just clarify. So I see there's a question which says, if I picked Bahamas before, I would like to pick the US process, do I need to release the Bahamas claim? Otherwise, my claim gets withdrawn. So let me just sort of walk through exactly where you'll end up based on what you've done. So when we say if you've picked Bahamas before, so there's 2 steps to the Bahamas process. There is submit a proof of debt, which you could have done since around March this year. And then there's submit your election to the on the portal, on our portal, about whether you want to be in the Bahamas process or the US process. And then there's also the voting ballot that the US debtors have set you, which has a tick box which says, I would like to be in the Bahamas, or I would like to be in, or not, I don't want to be in the Bahamas, by not ticking that box. So you will end up in the Bahamas process if you've done 2 things, as Jason said before. So the first is you must have submitted a proof of debt in our process. Second is, if you have elected to come to the Bahamas on our portal, or you have elected to come to the Bahamas process via the US ballot by ticking the I would like to participate in the Bahamas box, then if you've elected through either of those 2 methods, you will end up in the Bahamas process. So if you've done either of those two things and you no longer want to be in the Bahamas process, what you would need to do is amend your election. On our portal, it's very simple. You can just log back in, and any time up until the 16th at 4 p.m. Although I suggest you do it not on the last day, because there'll be a lot of people trying to access the portal. It might be a bit slow, but any point before the 16th, you can log back on and you can say, if you had ticked, I wish to participate in the Bahamas process, you can change your election to withdrawing your proof of debt, and that will make it very clear that you want to be in the US process from our side. However, if you have also in the US voting ballot ticked the I would like to go to the Bahamas box, you will also need to go and amend that election on the US side. And then that would require you to follow the instructions via the Kroll portal that the US debtors have sent you, or they've sent you via email. And I believe you can submit a new election form in that, sorry, a new ballot in that process. And you would need to submit a new ballot and then not tick the I want to go to the Bahamas box. So that's if you've already said you want to elect to come to the Bahamas. If you have only submitted a proof of debt in our process but have not elected in either, the default is you will remain in the US process. But we would still encourage you to go onto our portal and reaffirm that you wish to withdraw the proof of debt, so it's very clear. And again, that's as simple as logging on to the claim portal. Will take 5 minutes. And then you can just tick that I want to withdraw my Bahamas proof of debt, and then it will be very clear to us that you wish to remain in the US process. There's a few people sort of asking, I don't think there's a clear explanation on why we should choose one option over the other. I think, you know, as we mentioned, this whole process is designed not to have arbitrage between the two processes. That's what the GSA is designed for. So, you know, we don't believe that there should be any material differences. You know, there may be specific circumstances that mean some people want to choose one over the other. But as we said, from a distribution perspective, from a calculating the claim balance, from the forms you'll need to submit, it all should be fairly well aligned. We know that some people just wanted to deal with the Bahamas because they felt that they were dealing with FTX digital markets. From the contract perspective, also some people may be more familiar with a more sort of UK Bahamian-based insolvency type process compared to a US Chapter 11 insolvency process, because they're somewhat different in the way that they operate. So that they're some of the reasons that people have decided one over the other. But generally, if you're just a regular customer and you just want to get your money paid back, both processes should be fairly similar. And we can't really comment on people's individual circumstances, but we're not aware of anything at this moment that would mean that you know, if you're in a specific location such as EU or Australia or a particular part of the world, where it would be different, you know, going through the US process or our process. Jason, any other ones you can see there you want to pick up?
There's a question regarding whether or not we have a list of shortlisted payment agents or platforms. None that can be disclosed at the moment, just because some of those commercial discussions are still underway, unfortunately. But we know people are interested in that, and an announcement will be made as soon as that agent is selected and the contracting is agreed.
Yeah.
One person has noted a mismatch between the balance that they can see on their account. I'm not sure if they mean their FTX digital account, but the balance they can see on their account versus the balance they can see on claims.ftx.com versus the balance they can see on Kroll. It's hard to comment on individual cases. For the most part, the balances that you can see on the FTX digital markets portal should mirror the scheduled balances in the US. albeit sometimes with a little bit of a lag. But ultimately, if you're seeing a balance that you either don't recognize or don't agree with, you should just submit your proof of debt on a disputed basis and input the balance that you're expecting to see, and then your claim will go through the adjudication process.
Yeah, Jason, I think on that one, I'm seeing they're saying they're a client of FTX Europe. So as I sort of said earlier, I believe on the claims at ftx.com website, as a European customer, you may have seen the entire balance of your account. But as we mentioned earlier, FTX Europe customers are getting paid out through a separate process, which is not the same as the process we are running or the FTX trading process. So if you came onto, say, our portal, or you went onto the Kroll website and looked at just the FTX trading portion of your claim, that would only be for what is called the FTX EU crypto processing withdrawals. That is where you'd withdrawn from your account already, but you did not, that crypto withdrawal did not actually settle or complete into your wallet, verify into your wallet, so you never received it on the blockchain. So that is why I think maybe there's a mismatch from an EU perspective. Unfortunately, we're not sort of involved directly with how the actual main portion of the FTX EU account balances will be paid out, but the crypto withdrawal piece we have calculated. It's on our portal, and we can pay that out. But effectively, as an FTX EU customer, you will need to get two claims, one in the US debtors process via trading or alternatively our process, and then a second claim will need to be going through the FTX EU bankruptcy process. Just looking at the final questions, there's a few questions on stipulated amount as opposed to scheduled or voting amount. I believe that this is related to probably the US process, because in the US, I think you have a voting amount based on your class of claim. We can't really comment on that because it's going to be more of a US specific question. But effectively, the way we understand it works is in the US, based on the size of your claim, your voting amount will be based on your scheduled balance. But there could be circumstances where it's different. Someone's asking about impaired claim status. So again, impaired claim is more of a US term, and I think there's a number of reasons your claim could be impaired. I believe if it's less than $10 US, it might be classified as impaired, which means you have a claim but you're not going to get paid. And there could be a few other reasons why your claim could be impaired in the US process. You need to refer to the US guidance around that. Again, I think, from the Bahamas process side, it's quite simple. If you go onto our portal, you submit a proof of debt and you've been able to link your account, if that value appears and it's more than $0, that is the amount you'll be paid in the Bahamas. So if the US has said your claim is impaired, that will have no relevance on the Bahamian process. So as long as you put a claim in our process that says $5 and you've submitted it and you've either accepted or disputed the balance, if you elect to come to the Bahamas, then the US claim status is not relevant for that FTX.com account getting paid out. There's a question around FTT, and it's listed as 0, and what happens with the coins. So at the moment, the ruling around FTT, I won't go into too much detail, but it's based on the fact that there was an equity element associated with FTT, and due to the fact that FTX went into insolvency, that creates a special case for FTT coins, even though they're still trading. one thing that we would say is there is a lot of FTT coins. So just because it's trading on the stock market now at a particular number doesn't mean that if all those coins were released back onto the market, of which there was a sizable amount held in both unlocked and locked values by FTX, that it would actually, continue to retain that value. At the moment, what actually happens to those coins, I don't think has been decided. But from a valuation perspective, after going through extensive sort of discussions in the US, it's been valued at zero, and that's been the decision. It's possible that may change, and that there may be the ability to give FTT back, but I don't believe that is the case at the moment. And certainly for this main claims distribution process that's happening, they will remain valued at zero as it currently stands for now. Is the current thinking. Someone's just asking to confirm if claims increase or recovery of assets is lower, resulting in reduction, would that reduce US customers as well to maintain equity? Jason, do you just want to cover this one?
Yeah, as I mentioned previously, part of the reason why distribution amount ranges have been given is because the final amount will be dependent on the timing and the ultimate value of recoveries. Because the recoveries are being pooled across the Bahamas process and the US process for FTX.com customers, to the extent recoveries are lower, that will impact customers across those two estates equally. To the extent they're higher, that will impact customers equally.
There's a quick question around, if I choose Bahamas, will we have to pay some fees to PwC for their work? The answer is not directly. So whether you choose the Bahamas or the US process, you will not have to pay any fees to any of the insolvency professionals individually. Although, as you may be aware, that our fees are coming out of the estate, and that will sort of exist whether you choose the US or the Bahamas process. Both processes will occur, and you can look at the court file documents to see what those fees are and what makes up and what activity is being done for those fees. It says, what is roughly the percentage of, so there's a question around the percentage of payment expected in the first round for people greater than 50K. Is it closer to 50 or 10%? The answer is it is not being decided yet or disclosed. I think so we don't want to comment, and please don't hold us to this, but I think the expectation is it's probably going to be more than 10%, given that the projection is that we're going to pay out 100%. Likely it's going to be, somewhere a little bit more than 10%, but maybe not quite 50. So it's probably going to be somewhere in that range of a little bit higher than 10 to 50. But that is still being determined based on what assets are available to liquidate, how the payments will work, what ongoing litigation cases are there, and how many funds need to be kept in reserve. So just to sort of clarify why the convenience class gets paid out in full, the convenience class customers, while there's a very large number of them, when you add up that number, it's a very small total value in terms of the total payment that needs to be made. And because there's a large amount of very small payments, it's more efficient for the estate just to do that at once, and there'll be appropriate reserves to easily do that. And so that's why that first payment is being made in full in Q1. And then for everyone else, again, as per the sort of the US plan and the modeling, the estates are confident that we will be able to pay the same full amount to the people who are greater than 50,000, not in the convenience class, but it will just take longer for those assets to be available and the estates to be wound down to fully pay all the money back. And that's fairly typical of a liquidation process. But we will release more information on that later this year. And as we said, from an election perspective, it should be similar, if not the same, exact timing in the Bahamas and the US process for that first payment to non-convenience class customers. And it will be the same amount. So if we decide to do 30 cents in the dollar for the first payment, that would be aligned between the US and Bahamas non-convenience class customers. Someone is saying that they've got $100,000 for distribution, but showing claim status impaired. I think you would need to ask why that is in the US process and determine why it says the claim status is impaired. You may wish to inquire with the US. There could be some issue related to the claim. I'm not sure what it would be. You can still file for the Bahamas process if you want. And then you would be able to sort of go through the Bahamas process to have your claim paid. It would be adjudicated in the Bahamas process. If there was some special reason that the US has decided your claim is impaired due to it could be something like it's an insider account and we can't pay it, then that might affect the payment in the Bahamas ultimately. But yeah, I think I would encourage you to sort of dig further into the US process of why they've said that you're impaired. I think that person was saying the same scheduled amount as on the PwC portal. Yeah, so that would, yeah, I'm not sure why it would be impaired. But if the same scheduled amount is on the PwC portal, that is the current our current records for your claim. It says, would the fees for PwC and Kroll be split across both processes or only applied to respective customers? No, that is split across. It is shared across the process outside the customer recovery pools. So the PwC and Kroll and other professional advisors on both sides, those fees will not be. They'll be coming outside of the customer pools. So if those fees are sort of slightly higher or slightly lower than expected in both processes, then that's not going to affect the equality of the customer pool. US and Bahamas customers will still receive the same amount of distributions in both their process. I think we've answered the plan one before, but just for Michael, the plan doesn't pass, then we have to go back to the drawing board. So basically that means that we your election to come to the Bahamas process will effectively be void, and we would need to see then it might go through a new plan, and that would basically delay the entire distribution process for everyone. I think that's probably it. Just one final one. This is a question from Lars on the Kroll platform. Says the claim is submitted, confirmed and planned, and the PwC portal doesn't show this. There's slightly different terminology in the PwC portal, but effectively in the PwC portal, you should just be able to check at the moment that your claim is submitted and you've voted. That's the only thing you need to have done in the PwC portal. The next statuses in our portal in terms of adjudication and KYC have not opened yet. So if you wish to be in the Bahamas process, all that it should say in the PwC portal is that you've submitted your proof of debt and that you've made your election to remain in the Bahamas process. And then finally, I think we'll probably just close out here in terms of this is a question around the Q&A. Are we going to publish an updated Q&A on our portal? The answer is yes. We are going to probably today or tomorrow, sort of UK US time, upload an updated FAQ with some additional information to our portal. So yeah, please look out for that. Okay, so I think we're at time. So again, thank you everyone for attending. Hopefully that has been helpful to clarify some of the questions that everyone has. As I mentioned earlier, if you are having issues with submitting your proof of debt or your claim, please reach out this week to our support team using the email addresses on the Digital Markets claim portal homepage. And I appreciate that people do have questions about the rest of the process and the timeline and all of that. But as we mentioned, those details will be released in due course as we sort of head to Q1 next year, when we anticipate distributions will start. And we will communicate with you via our website and via the email addresses to inform everyone of next steps. And I anticipate that will probably start to happen from early September. There will be a little bit of lag time after the 16th while we look at who is going to be going into which different process between us and the debtors and splitting those groups into two. And then probably we'll be reaching out at some point, I think early September, to confirm the next steps from the Bahamian process in terms of KYC and adjudication.